And a very good morning to you. This is John Fradgley from the Bell Legal Group, back with you for another program of The Law and You this Tuesday morning. And just for a little bit of a change, we had a musical intro there this morning, which I hope you enjoyed. This is your opportunity to get free legal advice between now and 9:30. All you need to do is get on that telephone as soon as you possibly can. 55208888 is our number. That number again, 55208888. Don't forget, if you're south of the Tweed River, you need to put 07 in front of the number, but otherwise, if dialing from the north side of the Tweed River and right up throughout Queensland, just 55208888 is going to get you straight through. Or you can send questions on our email at talkback@4crb.com. And we have, in fact, received a query by email, and I'll deal with that in just a moment. But before we do that, I just wanted to send out a very big thank you to all of those people who renewed their support or became new supporters of 4CRB during our radiothon, which finished on the weekend on Saturday. In fact, I was fortunate enough to be here for the close of the radiothon and to speak with all of the happy volunteers who were here on that last day, which was a huge day of people calling in, pledging their support. And without those volunteers and all the staff here who work so hard during Radiothon Week, and of course you, our supporters, and the sponsors who donate prizes, we simply wouldn't be able to keep 4CRB running the way it is today, including this program, The Law and You, which is of course one of those programs that we're so happy to bring to you. Thank you to all the people who called in last week during Radiothon. I thought we were going to have a very quiet day of it last week, but in fact it ended up being one of our busiest programs. After a slow start, we had, I think, about 8 calls come through, which is getting around about the maximum that we can deal with in the length of time in the program. So once again, thank you to all of those people out there for continuing to support The Law and You. Don't forget, if you haven't paid your contribution for support to 4CRB as yet, don't forget to do that. Sometimes we get caught up in the enthusiasm of Radiothon and forget to do that, but our staff and volunteers are still here wanting to get all of those pledges in. So if you can just make sure, if you're one of the people who made a pledge during the Radiothon and you haven't paid your full contribution of $60 as yet, don't forget to do that. Just a gentle reminder. Now, as I said, we received a query by email yesterday, actually, from Angela, who wants to know what are the risks of leaving money in a house that is being sold and doing a first mortgage with a 20% deposit from the buyers over 5 to 10 years at a variable interest rate. She says that they would pay back principal and interest monthly, and what are the complications if the buyer defaults on the monthly payments? Well, of course, it is not uncommon for people to finance the acquisition of properties. I mean, that's what the banks do every day of the week, and they will often do it on a low deposit. 20% would represent a reasonable deposit. The dangers in that for you, Angela, are that if the value of the property declines and the buyers were to then default, then obviously you run the risk that there may not be sufficient equity left in the property to recoup your capital. What basically happens is that if the buyers default under the mortgage, then you have the right to you need to serve a notice of breach that they have failed to make their payment, and giving them time to remedy the breach. And if they fail to do that, then you can issue a notice of exercise of power of sale, under which, unless the breach is remedied within that time, you can then proceed to sell the property up. If the buyers are living in the property, obviously you've got to go through the process of getting them out in order to proceed with the sale. So there are a few things like that. One of the major things to watch out for too over the term of the loan is to make sure that the property is fully insured, and that your interest as first mortgagee is noted on the insurance policy. So the insurance is taken with a reputable company, and and your interest is noted there. Obviously, taking a first mortgage is critical. I certainly wouldn't recommend you do it on anything but a first mortgage. It's for you to decide whether you think 20% deposit is sufficient or not, and that would very much depend on the current value of the property and what you perceive might be any likely downturn in the market over that period of time. Bear in mind also that if you're receiving principal and interest payments, the principal in the loan is slowly being reduced by those payments, and so every month that the buyers don't default means that your debt is coming, or the debt secured is coming down, and that's increasing the equity available in the property. If the worst happened and the buyers did in fact default and you had to sell the property up and there was a shortfall, don't forget that under the personal covenants in the mortgage you would be entitled to sue to recover any shortfall, but that of course would depend upon the buyers having any income or assets from which that could be realised. So I hope that helps you with that, Angela, and all the very best. The most important thing is to make sure that you use a lawyer who is competent in that particular area, so that you ensure that your security documents are all properly prepared and executed. But enough of that. We have our first caller online. As we say, a very good morning to Bill. G'day, Bill. How are you today?
Very well, thank you, John.
That's good. How can we help?
I'm acting for a person who's got early stages dementia, and they've received a letter of demand. My query is, the letter of demand only has what appears to be a business name and an ACN. No other details about the address of the place of business of that entity. Is that a legal document?
Well, it would be a legal document, but does it set out the amount that's owing, and does it set out what it was for?
It just states an amount, yes. Doesn't really say what it's for.
Right, okay. Well, look, I would certainly not be paying it until you're satisfied that that it is a legitimate debt. The person that you're assisting, are they still competent enough for you to ask them about the matter?
Oh, yes. Yes, so, and they've given me a written authority to act on their behalf.
Right, and do they acknowledge that there is a debt?
It's at a dispute.
Okay.
And the amount is quite different from what he thought the debt might be.
All right. Well, if that's the case, then I would be contacting the people who've sent the demand. I mean, obviously, if you just simply go onto Google and put the business name in, it shouldn't be too hard to find a phone number to call, and asking them, just tell them that you're now acting for the person because they have early onset dementia, and that you want details of what the amount is for. You want a copy of the tax invoice or whatever it was that caused the debt, so that you can check that against the person's records, and that once you've done that, if you're satisfied in relation to the debt, then you'll arrange for payment.
Okay, thank you, John.
All right,
Much
Bill.
appreciated.
All the very best. And you're in tune with 4CRB 89.3 FM. The Law and You is the program. Our phone number 55208888. That number again 55208888. Please don't leave those calls to the last 5 or 10 minutes of the program like we had last week. If you do have a query out there at the moment, get on that telephone straight away 55208888, and that way we can not only help you, but we can also help other people that may be out there listening but can't get to the telephone at the present time. One of the things that I wanted to talk about today, which has been concerning me a little bit, is the number of royal commissions that we've been through in recent times, or are about to go through. We've had the Royal Commission in relation to banking, we've had the Royal Commission in relation to nursing homes and elder abuse, and then we've now got a Royal Commission coming up in relation to the abuse of the disabled. And it's not difficult to start to get a little depressed about all these royal commissions going on, and the inference that gives in relation to our society. But I just want to say that that one of the things and of course, don't forget the Royal Commission in relation to institutions, the churches, etc. The one thing I do want to say in relation to this is that we should try and avoid thinking that everyone in all of the organisations that has been the subject of a Royal Commission or is going to be the subject of a Royal Commission is in fact a bad person, and that these organisations are unworthy of our support. We need to bear in mind that sadly it is often a small minority of people amongst a sea of good that is being done in all of these organisations that are responsible for the tarnishing of the names of those organisations. And I think it beholds us all to spare a thought for the overwhelming majority of good people who there are in the churches and the aid institutions like the Salvation Army, etc., that are doing such good work, along with the many, many staff in nursing homes, those who deal with disabled people who are doing such a good job, and in fact the very many reputable bankers and financial advisors there are that who have been tarnished by the actions of a few. So just spare a thought for them. It may make you feel a little bit better about the world in which we live. But enough of that. We have Pam online. Good morning, Pam. How are you today?
Great.
That's good. How can we help you today?
I just wanted to ask a little piddling question about the law.
Sure. Can you just turn your radio off, Pam? I think you've got a bit of feedback going on there in the background.
Yes, I'll just turn it down. Just a minute.
Good on you.
A little piddling question about... Yes?
There we go. That'll be a little bit better. That'll make it easier for you to hear and for me to answer. How can I help?
Well, 2 or 3 years ago they built a unit block near us, and before that we had a view from one end of the canal to the other. And now, they built a whole lot of trees and cypresses right down to the water edge to the canal. And they're all grown up now, so blocked our view up to the north. Before I could see the fireworks right up to surface. Now, nothing. I just wondered if there was a law for these developers to not grow trees and block other people's views.
Look, I don't know that there is, Pam. I do know that in New South Wales there are certain laws in relation to the blocking of views. If there were, it would be a local government matter. And so what I would be doing if I was you is probably getting onto your local councillor and just asking them in relation to the matter whether there's anything that can be done. The difficulty always is with trees, because it's virtually impossible to get the council to agree for a tree to be lopped. So that's always a bit of a problem. The only time where there may be a little bit of latitude is where the trees are not a native species, and so therefore maybe if these are pines that may be an issue. But it's definitely a local government issue, and the only thing I can suggest you do, Pam, is call your local councillor, perhaps get them out to take a look and see what's happened to your view and see if there is anything that can be done in relation to it.
It's so ugly. I mean, whoever planted them didn't know what they were doing.
Right.
You know, and they've even blocked their own views. It's all going, up 2 and 3 stories now.
Right.
These big cypressy things.
Cypress pines. Yes. Okay. Well, the other thing, the only exception, as far as I know, in relation to the lopping of trees is when they're within a particular distance of a boundary fence. It's possible to have them cut down. But as I say, I think your local councillor would be your starting point to try and get something sorted out.
Righto, I'll try that. Thank you.
All the very best.
Bye.
And the time on 4CRB, 21 minutes past 9. The Law and You is the program, 55208888, the number if you have a question or a query. We're into the last 10 minutes of the program, so please ring quickly if you have a query, 55208888. And we say good morning to Brian. G'day, Brian. How are you today?
Morning, John. How are you?
I'm exceptionally well. And what about your good self?
I'm good, thank you.
That's good.
John, just a small query. my niece purchased a leather recliner lounge from a prominent retailer, furniture retailer, and it was purchased 2 weeks ago when she took possession of it, and it was found to be, the recliner found to be faulty. Now, the technician came out, had a look at it, and said, yep, it is out of alignment. So she approached the retailer and said, listen, I don't want this lounge. I want my money back. Now, they are refusing to return the money back to her. She says, they say that, well, she can purchase something else from the shop, which she doesn't want. And naturally, so the refund policies, which come under state legislation, which is Fair Trading Act, now that is quite explicit in what it requires. That if an item does not require, have the normal what it is intended for, it's a refund is should forthcoming. But was the technician able to fix the problem or not? No, he says he can't.
All right, okay. Well, if that's the case, then under the Australian consumer law, if the product is not reasonably fit for the purpose, then you are entitled. Yeah, you are entitled to a refund. So I would be getting on to. I would be getting on to the, I think it's the Australian Financial Complaints Authority, it may be, or certainly you can go through Consumer Affairs. Is it in Queensland or New South Wales?
In Queensland, yes.
Okay,
Queensland.
Well, what I would suggest that she takes the matter up with Fair Trading or Consumer Affairs, as they're called, they're called in Queensland. And they certainly should be able to point her in the right direction as to the course of action she needs to take to secure a refund.
Yeah, because they are refused. The emails have gone up and down between the two of them, and nothing has been resolved. So this has been going on for the last 2 weeks, and they are refusing to come to the party.
Right.
So
are they offering to replace the lounge with the same lounge, but one that's okay?
Well, they have made an offer to her, but I don't think she likes that offer because the way they're going about business. And naturally, she's got quite fed up about it, and she wants her money refunded. Now, QCAT will be the only course of action for her, isn't it?
Well, it may be that ultimately you will end up in QCAT, yes, and the complaint will be under the Australian consumer law. So she needs to Google the Australian consumer law and look up the causes of the rights and causes of action that are available under that to make sure that she pleads it correctly. What I would be doing first is writing a letter to them advising that, what they've offered is unacceptable, and that unless they agree to refund, that she's going to lodge a complaint with QCAT under the Australian consumer law.
Thanks, John.
Okay, then. All the very best. Bye now. And the time is just coming up to 25 minutes past 9 as we say a very good morning to Nan. G'day, Nan. How are you?
Hi.
Oh, sorry. Who is it? Ivan. Sorry, Ivan. I thought I must go and get an eye test. I had written down Nan. My apologies. How can I help?
Oh, John.
It is.
Okay.
It is.
John, I talked to you a few weeks ago and about a friend of mine that was divorced nearly a year ago, and you said that if she's concerned that her ex-husband might come back and go for settlement. He's been overseas for a long time and hasn't been paying maintenance or anything. So, and you said that after a year, if he hasn't made a claim after a year, after he knows that the divorce has gone through, that he can't come back to her.
Yes. Well, you can apply to the family court for an extension of time within which to bring a property settlement claim, and then it's up to the court as to whether they'll grant that extension or not. But the law is that an application for property settlement must be brought within 12 months of the date of the decree absolute.
And if it isn't?
Then theoretically you lose your rights, and the only way that you can extend that time is by application to the family court, and you have to explain why you should be entitled to extend the time. and obviously the other party has the right to resist that and say why they think the time should not be extended.
Okay, well, we're thinking that for her peace of mind and getting on with her life where she hasn't got that over her head, that she goes through the family law court now with that, and if she gets a ruling on that, that would be the end of it, wouldn't it?
Well, I don't really see any reason why she would bring that application, Ivan. I mean, the law's pretty clear. And look, the more time that goes on once that 12 months has passed, the less likely it is that the other party would get leave to extend the time to bring that application. What part of the Gold Coast does your friend live?
Helensvale.
Helensvale. Okay, well, look, what I would suggest you do is call the Gold Coast Community Legal Service. Have you got a pen handy?
Yeah.
Okay, so 5532.
Yeah.
9611. Now, they operate free legal clinics up and down the Gold Coast, and I know they operate up around the Helensvale area during the week. I just don't have in front of me the dates, etc., or the days, etc., or the times they do it. But if you ring that number I've given you, they will be able to tell you, and she could make an appointment and go in and see them. So and chat right through the whole thing because I think it's far better that she get advice specific to her circumstances, and that needs disclosure of more information than I want to be made public on this show, because obviously I don't want information made public that it could in any way identify a person. So I would suggest that you get her to ring that number, 55329611, the Gold Coast Community Legal Service, and she should be able to make a time to go and see them up around Helensvale.
Okay, I've got one more if you got time. Sure. Okay. She also has a commercial office that she owns, and the tenant is had a 2-year lease and has just walked out after 6 months and just says adios and just gone. So she's got a proper legal tenancy agreement. What's her avenues now to sue that person, or to...
Well, clearly the person has abandoned the premises. Have they taken all of their belongings out of it? So whatever they had in it, so they've clearly abandoned the premises. So what she needs to do is to serve them with a notice in accordance with the Property Law Act that she's terminating the lease and reserving her right to claim damages. So I would recommend that she engage a lawyer to do that. And then she should take immediate steps to re-let the premises. And if she doesn't achieve the same rent as she currently was getting, then she's entitled to sue for the difference in the rent over the period of time, plus any lost rent for weeks or months when the premises were vacant. If she achieves a higher rent, then her claim would simply be for the rent lost between the date the tenant stopped paying and the date that the new rent started. Okay, and is that done through what court? Look, it would depend on the amount involved. It could possibly be done through QCAT, which is the Queensland Civil and Administrative Tribunal, or alternatively it would probably be the Magistrates Court. All right then? Okay, thank you very much. All the very best. Thank you. And that's all the time we have for today. This is John Fradgley from the Bell Legal Group. I look forward to being back with you again sometime soon for another program of The Law and You, in fact next Tuesday morning. But until then, as always, it's goodbye and God bless.